Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 128. Just me this time round, sorry. Anyway, I hope you enjoyed the end of the year review podcast that I did with Miriam, and then the one that we put out last week dealing with cases of potential significance for employers, which are scheduled to be heard in 2018. As we said on the most recent podcast, I'm sure we'll be hearing more about those cases as this series continues. In view of what Miriam said in that last podcast about doing a case which had first surfaced in episode 3 of the podcast, I went back and looked at this. Do you realise we've been doing this podcast series for something like 5.5 years now? That's truly remarkable. Still no sponsor, of course. Audible Books, Squarespace, where are you? Anyway, 3 cases this week, and at the far end a podcast recommendation for you. That podcast has been going for rather less time than this one, but I strongly suspect it's got considerably more listeners. Well, the 3 cases we're looking at this time cover whistleblowing, perceived disability discrimination, and an update on a case I dealt with in an earlier podcast, number 113, on collective bargaining. As always, you can access the podcast via iTunes, the Mayor Brown website, YouTube, Twitter, and my Twitter handle is Nicholas ROBER11. And there we put out the links to the cases as well. So, Parsons and AirPlus International Limited. This case deals with whistleblowing, which, as you know, we've covered a fair amount on this podcast series because the area does keep identifying difficult legal and practical issues for employers. This case is no different, although from the employer's point of view, there was a happy ending. The simple factual summary is that Ms. Parsons was employed by AirPlus for all of 6 weeks in 2015. However, it seems to have been a fairly eventful 6 weeks. She's a lawyer. She joined them as their legal and compliance officer. However, almost immediately, she started raising concerns about matters about AirPlus being in breach of its legal and regulatory obligations. She was concerned they didn't have a consumer credit licence, although the company believed it didn't need one. There was no money laundering reporting officer, but again, the company took the view it did not need one. She was rude and disrespectful towards senior management, they felt, when she was raising concerns. And AirPlus did try and address some of her concerns about her going to prison for AirPlus's alleged breaches. For example, they changed her job title by agreement with her. But in the end, AirPlus decided she was a cultural misfit. Her performance and conduct was such that she simply did not fit, they said. And in the rather graphic words of her line manager, she left behind, quote, burnt soil, unquote, pretty much everywhere she went. Doesn't sound to have been a particularly happy relationship. Anyway, having been dismissed after only 6 weeks and with only 2 weeks' pay in lieu of notice, she of course claimed that the reason she was dismissed was because she'd been making protected disclosures. The Employment Tribunal rejected her claim, but went off the rails a little bit in coming to that decision. And one of the reasons it gave for rejecting her whistleblowing complaint was that she was not making AirPlus aware of anything that it was not already aware of. Now, as we know, and as the EAT pointed out on appeal, that by itself is not a ground for rejecting a whistleblowing disclosure. In many cases, if you think about it, a rogue employer may know full well what it is doing and that it is wrong. But to deny protection to a whistleblower because they are telling the employer something it already knows would be denying protection to people in circumstances where possibly they need it more than ever. However, the other aspect of the case at the appeal stage is more interesting. The Employment Tribunal decided that one of the reasons that these were not protected disclosures was that Ms. Parsons was not raising matters in the public interest. She was, they found, raising concerns solely in her own self-interest. On that basis, the tribunal said the disclosures did not qualify as protected disclosures. It went on to find that the reason why she was dismissed was that she had been rude and irrational when raising concerns. She'd been unable to substantiate concerns when asked about them, and accordingly her conduct was the cause of her dismissal rather than the underlying disclosures. The Employment Tribunal said here it was possible to separate the 2 different matters, her conduct and the disclosures. Ms. Parsons appealed, but the EAT agreed with the Employment Tribunal on this main issue. The leading case in this area is, of course, the Chesterton and Nur Mohammed case, which we dealt with in a recent podcast. As we know, it's possible for an employee to raise matters which are both of self-interest and with a public interest element in them as well, in the reasonable opinion of the employee. On the facts, as the Employment Tribunal had decided that the basis for the dismissal was her conduct and her inability to give rational explanations for the concerns which she was raising, that was a factual finding. In the circumstances, the Employment Tribunal had come to a finding it was entitled to. Once that was sorted out, it was unassailable, and if Miss Parsons had raised matters purely in her own self-interest without any regard to the public interest, her claims were, in my terms, doomed to failure. So what do we take from this case? Well, I think the first thing is this is a pretty extreme set of facts. If an employer is faced with an employee raising complaints or concerns which are a mix of self-interest and, it's asserted, are in the public interest, then an employer may well be found to have dismissed and breached the whistleblowing legislation if they get rid of the employee. The difficulty, of course, for the employer is that the employee may, by the time a tribunal hearing comes round, have their public interest concern well polished for evidential purposes and be able to articulate it very clearly. For this reason, I think that if an employer is minded to try and argue that there is no public interest element in the disclosures, it's going to be essential that the employer engages with the employee before the dismissal to try and get to the bottom of whatever are their concerns. Secondly, arguing that there's a distinction between the employee's willingness to raise concerns and the employer's willingness to listen to them, and the employee's conduct and the manner in which their concerns are raised, is a viable strategy, but probably only in extreme cases. As the EA pointed out, a genuine whistleblower may be perceived as a very difficult person or awkward by his or her colleagues. It is true that often whistleblowers take a lonely stand, for better or for worse. That does not mean their concerns are any less deserving of protection. However, clearly, there is a line beyond which whistleblowers should not cross when raising concerns, and here Ms Parsons seems to have crossed that line sufficiently to allow the Employment Tribunal to say that the company's concerns over her performance and conduct were not related to her willingness to make alleged protected disclosures. So, overall, it's a helpful case, but one that we mustn't forget is fact-specific. That's Parsons and Airplus International Limited. Next up, Chief Constable of Newark and Coffey, COFFEY. This case looks at whether an employee who is perceived to be disabled, but who is not in fact legally disabled, is entitled to protection under the Equality Act. You might think this is a situation would rarely arise, and so it's of little practical importance. As I hope to explain shortly, I think this case has rather wider implications. If you start with the legislation, the Equality Act says that someone is disabled if they have a physical or mental impairment, and this has a substantive long-term adverse effect on their ability to undertake normal day-to-day activities. That seems fairly clear-cut, doesn't it? Someone has to have a physical or mental impairment, and so on. It doesn't say anything about the individual being perceived to have such an impairment. However, in other strands of discrimination protection, it's well established that individuals who are perceived to be of protected status can claim protection, because the test for discrimination is adverse treatment on matters related to a relevant protected characteristic, is not necessarily the victim's protected characteristic that the legislation protects. This case concerned a woman who worked as a police constable for one police force. She had a hearing impairment, but the hearing was, I think, just the right side of the line, and she was able to pass a practical functionality hearing test and didn't require any other adjustments at work. She then applied to transfer to another police force. They took a rather less benign view of the situation, and she was turned down for that job on the grounds that she didn't meet the national standards on hearing. She then claimed disability discrimination, although her hearing was such that she did not require reasonable adjustments to do her job in full. The police force said they'd rejected her on the grounds that they could not take the risk that should join them, her hearing would then deteriorate and she might not be able to undertake all of the tasks expected of her. The AT decided the police force perceived that the woman constable had an actual potential disability, which could lead them having to make adjustments to her role to enable her to do her role properly. Therefore, she was not taken on. The fact that this was not borne out of the medical evidence, the risk of deterioration, didn't alter that analysis. The police force had rejected her because they had thought she had an actual potential disability. As such, this was direct disability discrimination. Police force appealed to the AT, and the AT dismissed the appeal. The AT accepted. The evidence showed that at the time they had rejected the application for a transfer to the role, the new force thought her condition, although not disabled at that point, might deteriorate to the extent where she would need to be put on restricted duties. There was therefore a perception the individual had an adverse health condition which might progress to the stage where, at a future point, the individual was going to be seen as disabled in the eyes of the law. Moreover, the police force could not have a defence to avoid being found to be liable on the grounds that they genuinely believed she would not be able to do the role. When establishing a valid comparator to look at whether someone has been treated adversely for discrimination purposes, the employer could not point to someone else about whom they had an erroneous belief that they would not also be able to do the job. That would be to sidestep the protection of the legislation altogether. The proper comparator was someone who had the same abilities as this individual, but where the police force did not perceive there to be a risk of a deteriorating health. On that basis, it was clear she'd been adversely treated on the grounds that she was perceived as disabled, and that was direct discrimination. So why do I think the case is significant? Well, the short answer, I think, is that it offers another way for claimants whose health is just one side or other of the line to say either I'm disabled, and as such you treated me adversely in a discriminatory manner, or you perceived that I was disabled, although I'm not, and that's why you treated me in the way you did. Clearly, as you know, an employer cannot close its eyes to someone's health and claim that because they did not realise someone was disabled, they necessarily escape their responsibility. If the employer, broadly speaking, ought reasonably to have realised that the individual is disabled, then the law provides protection. Here we're in a slightly different situation. The individual is in fact not actually disabled, but has been treated adversely for, let's say, health-related reasons. Now, because of this case, an employee can argue that even if their health issues are not such as amount to a disability in the eyes of the law, perceived disability opens up another avenue for a claim. Say, for example, where an employee has a single short incident of ill health caused by, let's say for the purpose of this example, mental illness. Let's also assume that on the facts there is no reason to believe the employee will have another episode of adverse mental health. However, the employer dismisses them and the employee brings a disability discrimination claim. Once it's accepted that the incident is short-term and unlikely to reoccur, it's probably not going to amount to disability discrimination in the eyes of the law. However, if the employee is able to show that the employer had made adverse comments about people who have previously suffered from mental health issues being likely to suffer again, then it's a short step for the employee to say that the employer, in my hypothetical example, has an irrational fear which has led to treating the employee adversely on the grounds of perceived disability. Now, it's true that the courts have decided that the employer, in my example, would have to perceive that the individual was going to have all of the characteristics necessary to qualify as disabled, i.e. physical, mental impairment with substantial long-term adverse effects, to ability to carry out normal day-to-day activities. But in reality, I wonder how much of a substantial hurdle that would be in the example which I've just given. In short, I think that employers who are treating individuals adversely on health grounds or for health-related reasons probably need to tread a bit more carefully, particularly when dealing with something that might be perceived as a disability if it was going to reoccur in the future. So that's Chief Constable of Norfolk and Coffey. Now my third and final case is one I've dealt with before, Kostal KOSTL UK Limited, Dunkley and others. Now I dealt with this at the Employment Tribunal stage back in podcast number 113. It has now gone to the AT, and as I think the case is an important one, I wanted to come back to pick it up again briefly. Background is that Kostal were required to recognise trade union following a ballot in February 2015. A collective bargaining arrangement was then reached with the union, in which it was recognised that it was agreed there would be annual pay negotiations, and that proposed changes to terms and conditions of employment would be something that would be negotiated with the union. It's a fairly standard collective bargaining agreement from the sound of it. First pay round that came up was for 2016, but things went off the rails fairly quickly. The company was, broadly speaking, willing to offer a 2% pay rise with a Christmas bonus on top of that, but they wanted to cut back on some of the employees' benefits, things like sick pay and rest breaks. This was all put to the workers in a ballot, and it was rejected by a significant margin. Kostal then follow up with a direct communication to the workers saying that they were going to make a direct offer to each of them, and it was the same offer because they said a failure to agree the revised T's and C's would mean that there was no Christmas bonus and no pay increase during the year. There was then a follow-up letter sent by the employer after Christmas saying that employees wanted to take advantage of the pay offer which had by that stage been modified, then they needed to accept it expressly. But it also threatened individuals who did not sign up to the revised pay round with the authorised pay offer. It threatened them with notice of termination. Well, a group of employees issued a claim arguing there had been breach of Section 145B of the Trade Union and Labour Relations Consolidation Act. In general terms, that provision makes it unlawful for an employer to make offers to members of a trade union recognised by the employer, where one of the outcomes of the offer is that terms will no longer be determined by collective agreement. This is what the legislation calls prohibited results. Now, the burden of proof is on the employer to show the reason for writing directly to the employees. There is mandatory compensation for the offer if it's found to be a prohibited result, and at that point in time it was £3,800 per successful claimant per discriminatory incident. The Employment Tribunal decided there had been a prohibited result, and, more surprisingly, that the letter before Christmas and the letter after Christmas were two separate letters with two separate prohibited results, and as such, each claimant got two lots of £3,800. An expensive issue. Unsurprisingly, the employer appealed to the Employment Appeal Tribunal. Now, the EAT wasn't unanimous on this, interestingly, but by 2-1 majority, they rejected the appeal. Costal's main argument was that there was only a prohibited result if the employer's offer was to end collective bargaining altogether. In other words, if the offer was have a pay rise in return for employees accepting that they should no longer be represented by a trade union for the purpose of collective bargaining, that was the mischief caught by the legislation. But the EAT did not accept that. They said that because this offer would take the pay round out of the collective bargaining this year, that was sufficient. Here, the employer's offer would have determined this year's pay round. That would mean collective bargaining arrangements did not apply to this year's pay round because it had been being settled directly. The EAT did assert that this did not give trade unions a veto over terms and conditions of employment. If collective bargaining breaks down and the employer has a legitimate purpose behind writing directly to its staff, the EAT said, then such offers can be made directly. However, here, it was felt that the offer, the rationale stated for the offer, which was a desire to ensure that employees had their Christmas bonus, couldn't possibly apply to the letter which was sent after Christmas. And secondly, the Employment Tribunal had been entitled to find, on the facts, it was, quote, exceptionally improbable that there was any other intention behind the two offers other than to take the pay review out of the scope of collective bargaining. We're hearing reports that trade unions are asserting this case does in effect give them a veto power, even though the case in the EAT clearly says it does not. However, the problem is that having found that each letter amounted to a prohibited result, the workforce have come out of this considerably better than the employer ever intended. I also think the problem for employer is to know quite what the EAT would view as an acceptable circumstance for making a direct offer. Remember here, the employer was wanting a trade. In other words, it was willing to offer a pay review and a particular pay rise in return for cutting back on certain benefits, and that was not something that could ever be imposed unilaterally. It did require each individual employee's consent. In what circumstances do we think it would have been legitimate for the employer to write directly to the workforce? Should there have been more meetings? How many meetings? How many months had to go by before the employer would have been entitled to write directly to the workforce? Would it make any difference if there was evidence that the workforce wanted the workforce to have the opportunity to decide matters directly? I don't know whether this case is going to go on appeal, but it is clearly an important issue, and it wouldn't surprise me if the employer felt sufficiently strongly to launch an appeal. However, I'm not sure that the facts as found by the tribunal are terribly helpful for an appeal. Clearly, writing to employees threatening to dismiss them if they don't accept the offer, which was what apparently happened in the second letter, is fairly strong conduct. Well, we'll definitely keep an eye on this, and if it looks as if either this case is going to go to the Court of Appeal or there's going to be some follow-up, then we'll cover this again in another podcast. So that's the case of Costal UK Limited and Dunkley and others. So thank you very much for listening to the podcast as always. I said I'd say a few brief words on the other podcast series that I would recommend. For those of you who are fans of Aaron Sorkin, and indeed I recently saw his film Molly's Game, which I think is very good, there's a wonderful podcast series based around The West Wing, which of course he was the main writer on. And they did that something like 20 years or so ago now. Well, if you like The West Wing, I cannot recommend the West Wing Weekly podcast to you highly enough. It's on all the usual locations online, and the title, astonishingly enough, is the West Wing Weekly Podcast. They go through each episode in turn, and even if you've seen each episode of the first few seasons as many times as I have, there's still a lot to learn about what's going on. Equally, frankly. If you've not seen the West Wing series itself, can I just strongly recommend that series? Watch the series and then listen to the podcast. But don't forget to listen to this podcast too. So, anyway, stay safe until next time, and in a couple of weeks' time, I'll be back with podcast number 129.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.